Thanks for staying with us. I'm Bill O'Reilly, and here's a legal segment tonight. 3 hot topics, beginning with a stunning decision by the U.S. Supreme Court. In a 6-2 ruling, justices say that voters in Michigan have the right to change their state constitution to ban affirmative action in college admissions. This now to explain, attorneys and Fox News analysts Kimberly Guilfoyle and Lise Wheels. So this began in 2006,
right,
when there was a referendum in Michigan, and overwhelmingly it passed.
By 58%.
The folks there don't want, when you apply to a Michigan college, race to be taken into any consideration.
No preferential treatment.
And the Supreme Court took 8 years.
Exactly.
8 years, you see.
Well,
to say, yeah, okay, that's okay.
It had to go through the appellate process.
Of course,
the Sixth Circuit,
of course it does.
In a decision in 2012, struck down that referendum that passed again by 58%, and said equal protection, you know, it should be struck down. Today, just today, the Supreme Court, as you said, 6-2, Kagan was recused herself because she'd been involved earlier, said, no, if a state passes this saying we do not want preferential treatment based on race or gender or what have you, we will allow the state voters to decide that. And now that is the law in Michigan, as it is in about 7 other states.
Okay,
and you know why?
It's a state-by-state call.
Correct.
The federal government's not imposing anything, right?
Because there is no authority in the U.S. Constitution to undermine elections, and this is a state election where they put this proposal forward.
No, they're undermining the gay marriage election in California.
Well, so there's some inconsistencies here then with their legal reasoning.
Absolutely.
Put the spotlight on.
It's always the same argument. Yeah. You're doing the human rights thing. You know, you pass a law that restricts affirmative action. That's going to unfairly target African Americans or Hispanic Americans, and you're going to pass a law restricting gay marriage. That's unfairly targeting homosexuals.
Right.
So it's always the tension. But I was surprised by
the 6-2. I was as well.
6-2. I think it was a pretty surprising decision.
Went along with
Kennedy, I could see. Breyer is
Sotomayor, apparently her dissent went on for days.
Because Sotomayor comes at it from a very ideological point of view. I mean, and she states it. She says it.
Well, she's overt about it.
She doesn't believe that the Constitution is a document that doesn't change, all right? She sees the Constitution as having to change for the social good.
Living, breathing.
Which is a very different viewpoint versus a
that's
strict
who she is, and that's how she's always going to vote.
Now,
and then, you know, Ginsburg is always going to vote liberal no matter what it is.
58% of the electorate voted for this in Michigan back in 2006, so that's their right to do so.
So this nut in